Thank you, Kelly, and thank you everyone for joining us today to talk about this exciting topic. We'll leave lots of time for questions at the end, so please do write those down if you have them. Just by way of introduction, my name is Jamie Gullen. I'm a supervising attorney at Community Legal Services here in Philadelphia. And CLS, as many of you may know, has been working on criminal records issues for several decades now. And we've been representing people in the pardon process in particular over those decades, and have been involved over time with efforts to try to reform the process to make it work better for our clients. So that's really the kind of background and context of the presentation today. So just to give you a little sense of what we're going to walk through, we're going to talk a little bit about some background information, move on to the basics of the pardon process, and then also talk about some of the recent changes to that process. We'll talk a bit about the new Expedited Program. You may have seen some news about this. It's specifically for marijuana convictions, so we'll talk about that. We'll talk about some areas for potential future reforms, and then end with taking some takeaways for your practice. If you already do pardons, or if you're looking to try to do more pardons, we'll talk a little bit more about that. And then we'll leave lots of time for questions at the end. So those of you in this work probably already know all of this, but I always just like to start by kind of grounding in the scope of the problem we're talking about here, which is that 1 in 3 Americans have a criminal record of some kind, and half of all children in America have a parent with a record. And when you combine that with the fact that 90% of employers, 80% of landlords, and 67% of colleges screen for criminal records, it becomes very clear that criminal records are one of the leading economic barriers for people to be able to get their basic needs met and to have economic opportunities, which is obviously what we as legal aid programs are all about trying to remedy. And in particular, for the pardon process, I thought this statistic was really useful, which is that people with felony convictions in particular account for 8% of the overall population and 33% of the African-American male population. So this issue, especially of felony convictions, is really impactful on people's lives, and it has a racial justice component as well. So a little bit of background about various record clearing remedies. We're here to talk about pardons today, but I just wanted to kind of give the 30,000-foot view of what the different ways to clear up a record are and why the pardon process, though somewhat long and difficult, is so important for our clients. So those of you who practice in this work know this, that, we have something called expungement, but it's pretty limited in scope. It's mostly just for non-convictions. But the great thing about an expungement is that it fully destroys the record so that nobody can access it anymore. And then, as you may be familiar, we have a new clean slate law in Pennsylvania that has 2 components to it. One is an automatic component where records are sealed from public view automatically without anybody having to file a petition. But it's for more minor records like non-convictions or old and minor summary and misdemeanor convictions. And law enforcement, the courts, et cetera, still have access to that, and they still show up on FBI records, unfortunately. So we can talk more about that later, but basically it means that some people are going to benefit from clean slate on conviction records and may still want a pardon for various reasons. And that's true for clean slate by petition also. That applies. Eligibility was expanded to some first-degree misdemeanors for the first time, where people can get those sealed from their records, which is wonderful. But because especially of the issue of them showing up on FBI records, for workers who are going to be applying for jobs that require FBI background checks, again, sealing might not be a completely sufficient remedy for them, and so they might need to also seek a pardon. And then finally, we have the pardon process, which is what we're going to talk a lot about today. And it applies to, in theory, any conviction. So as you can see, sealing only applies to misdemeanor convictions. So if you have a felony conviction, you're in the pardon lane for now. And a pardon makes your record eligible for expungement so that it can be fully destroyed, but it's a much longer and more difficult process, as we will see. So yeah, unless you're over 70 and have a 10-year arrest-free period in which you can get your convictions expunged, the pardon process is the only remedy for removing felony convictions from a record in Pennsylvania. We hope that will change in the future with changes to the clean slate law, But for now, the pardon process is really the only remedy for most people who have a felony record, and that's what makes it such an important tool in our record clearing toolkit. So what is a pardon? A pardon is a process by which the state grants clemency or forgiveness to those convicted of crimes, and what that means is that it fully restores people's rights, and it makes those records then eligible for expungement. And the power to grant pardons actually derives from the Pennsylvania Constitution, Article 4, Section 9, which is a fairly detailed provision if you ever have a minute to look at it. But it basically gives pardoning power to the governor of Pennsylvania, subject to recommendation from the Board of Pardons. And the Board of Pardons is made up of 5 members. 2 of them are elected officials, and that's the Lieutenant Governor and the Attorney General. And 3 are appointed representatives. There's a victims representative, a psychiatrist, and a corrections expert, and they serve for various terms of years and are then replaced by appointment. So in order to be recommended to the governor for a pardon, 3 out of the 5 members of the Board of Pardons have to vote in your favor. And in order to get a commutation of sentence for those who are still serving sentences and are incarcerated, you need all 5 members to recommend you. Also required by the Constitution is that there are public session hearings with public notice given before somebody is recommended for a pardon. The idea behind that is that victims, district attorneys, other interested parties to the case have an opportunity to be aware that this is happening and can even come to the public hearing and make statements if they so wish, which does not happen super frequently, but it is a part of the process that needs to occur by Constitution. So again, receiving a pardon fully restores the rights of the individual person convicted, and there's really good case law on what a pardon means, and this quote is the one we find most useful. Sometimes we need to use this with employers in certain situations to explain why a pardoned case that they may know about can't be considered. So the case says that a pardon blots out the very existence of guilt so that in the eye of the law, he is thereafter as innocent as if he had never committed the offense. So that's just kind of a helpful citation to have in your back pocket if you ever have a client who's facing some kind of discrimination based on a pardoned case. But although just the act of getting your signed pardon gives you this sort of restoration in the eyes of the law, until you actually go to file an expungement petition with the court, the record is not destroyed. So expungement is as of right. There's no discretion for a judge to deny it. A district attorney might object, but they have no legal basis to do so. So it has to be expunged, but you still have to file the petition. And at one point, we had heard some statistics that were troubling about that a lot of people who get signed pardons actually don't take that final step to file the expungement paperwork, which is another reason why having legal aid involved in this process is so important, to make sure that after going through all of the effort and all of the time to get a pardon, that people are actually getting their expungements to effectuate it is really important. So I've already kind of alluded to this, and you may know yourself, but the pardon process is quite long. And the reason it's long is there are a lot of different stages to it, and each stage takes time. So after you put in your application, you send it away, it can take about 2 years for it to be filed, accepted, reviewed, and then assigned to a parole agent who comes to somebody's house, investigates, asks them questions, asks to see documents, talk to other people they live with, and then the parole agent writes a report. Then takes about another year after that happens for the board to vote on whether to extend a public hearing. And the board 2 out of the 5 board members need to vote in favor of somebody getting a public hearing. And then if the person gets the public hearing, which is held in Harrisburg in the Capitol building in the Supreme Court courtroom, and it's, a bunch of people are all kind of heard at the same time, and then they call out the votes that day to decide if you're going to be recommended. And so if you're recommended, it can still take another year or more for the governor to then sign off on the pardon. The governor has no constraints whatsoever about whether to sign or not, or in what time period to act on pardons. So it can really vary. For a while, we were seeing kind of a backlog where I had one client waiting for 2 years to get her pardon signed by Governor Wolf. But now it seems like it's taking about 6 months on average for the governor to sign pardons. And it's, in our experience, very unlikely that if somebody is recommended, they're not going to get the pardon signed. But again, it could be any length of time before that happens, which can be very frustrating, as you can imagine, for clients who have gotten to what feels like the end of the line and have gotten their recommendation, but then still need to wait to actually get it signed. And then again, after they get that signed, that's still not the end of the process. Then it can take about 6 months for the case to be fully expunged from the court system, from the state police, from the FBI databases, etc. So in total, from beginning to end, we usually advise clients that the process can take 4 to 5 years. And as we'll see a little bit later, there's hope that that will get cut down, and there are various efforts underway to try to speed things up. But for now, for the regular pardon process, that's still about the length of time it takes. So what are the eligibility requirements to get a pardon? There aren't a lot of concrete written in stone guidelines. The ones that do exist are that the applicant must have successfully completed court-imposed requirements, so they can't still be on probation or parole, and they must pay their fines and costs, at least by the time they get to the hearing phase. We have seen recently that clients have been given what's called a conditional pardon if they still owe fines and costs, and we've heard that from other folks. But it's unclear to us whether conditional pardons will be expunged or if people will run into issues with that. We know the court has long said if there's any kind of balance, they won't expunge an offense. So really the best practice in our mind is to try to help clients get their balances paid by the time they get to the hearing, so they can just get a straight up pardon without any conditions and can get it expunged if they're at all able to do so. And if you're looking to see whether a client owes money, you can look at the court dockets. If there's supervision fees, which are noted as OSP, those can be waived by the court under Pennsylvania law. Otherwise, the individual has to pay either through a payment plan or, if they can, through a lump sum to resolve those debts. And then I skipped over the first bullet point here, and we'll circle back to it now to say that other than those requirements, there's this kind of vague sense that an applicant has to demonstrate a reasonable period of time having elapsed since the crime to show that they've been rehabilitated. And so traditionally what we've said that means in our office is at least 5 years since the time probation ended on a misdemeanor conviction case and 10 years on a felony case. And in the past, we would also kind of look at cases where people had fewer or less serious convictions on their record. But it seems that this board, in an era of wanting to try to extend the pardon process to more people, may be somewhat more forgiving than boards in the past. We recently had a client who had 20 plus conviction cases on his record, but they were all several decades old, including some for felonies. And he was able to get all 22 cases pardoned and expunged. So we're starting to kind of broaden our view of what makes somebody a quote unquote good pardon candidate. In terms of the reasonable period of time, if it's a really sympathetic case or a really good story or not that serious of an offense, people might want to try sooner than 5 to 10 years, but that's kind of always been our approximate marker of what a reasonable period of time would look like. So I think we'll still have some work to do figuring out how much that's changed with this board. Most of the cases that are there now, people filed years ago, and most of them are very old, so there haven't been a lot of chances to kind of test how the board would take a more recent case. So here's the good news, is that even though it's still a long and hard process, it has gotten so much easier. I recently helped my first client submit an application since some of these changes have gone into effect, and I was telling Kelly on the phone earlier that the changes are happening so fast and frequently that I realized a new change to the process this morning as I was preparing for this webinar. So my biggest piece of advice is always go straight to the Board of Pardons website, which is linked here on this slide, and always download the application fresh from the website, because they've changed it quite a bit, several times over the past month even. And they have really extensive and extremely helpful information on the website about all of the requirements and what's changing and the new expedited process. So that's sort of the first one-stop shop for any kind of information about the process. But here's kind of an outline of what's changed. So it used to be that the application was extremely long, very complicated, and it required a lot of money and time to gather a variety of documentation. And so some of the main ways that the board has changed that is that there used to be a requirement to get your access and review report from the state police, which costs $20 and can take 6 months or more to come back. They've thankfully eliminated that requirement. The same with the requirement to get a driving record from PennDOT, that no longer is there. The change I noticed this morning is that they're no longer requiring the 2x2 photo, as far as I can tell from the application. I had not heard about that change, but it's no longer on the application, which was great because that was just another thing clients had to try to go and do and spend money on. You used to actually have to pay to send away for the application itself, and now it's available for free online to be downloaded, or you can request a paper application for free. You used to also have to apply to send in the finalized application, and they eliminated that fee as well. And the application itself has been way simplified, which is great. So the current application, so what's left of this process that people need to navigate, is filling out all the basic information about their case and about any other juvenile or criminal records they may have. And that's for people to do to the best of their ability. We've had communications with the Secretary of the Board of Pardons, Brandon Flood, about the fact that, for example, some people's records are being automatically sealed under clean slate. So they may not know that they have an old arrest they've forgotten about, and you as the advocate may not be able to see it online. So are people going to be penalized if they forget to report something that's been sealed or something that's a juvenile record that you might not be able to access for them? And the answer is people should just do the best they can to their recollection and to the information they have available, and they're not going to be penalized if they forget or miss information. The board has ways of accessing that information anyway, so they're going to see it, but they're not going to hold it against people if they just honestly forgot or didn't know to report something. One of the good changes is that people do not need to disclose any charges or cases that have been expunged. So if it's been expunged, you don't have to worry about it. The next part of the application process, after you go through sort of that detailed record-based information, is there's a short, I guess you could call it an essay or a statement, where the individual has to describe what happened leading up to the offense. And this is the part where we've always said traditionally that it's really important that people take responsibility for whatever happened. It's very common in our practice that we'll talk to clients who will say either that they weren't involved in the incident at all and that they were totally wrongly prosecuted and convicted, or they were involved, but things didn't shake out the way the police report makes it sound like they did. The first case is harder because if a client says it really wasn't me and I wasn't there and I wasn't involved at all, we would never encourage a client to lie. And so that kind of is what it is, and they can try, although the board has traditionally been skeptical of that. More frequently, though, we have clients who say, like, yeah, I was there when my cousin was selling drugs, but I wasn't involved in it. And so in those types of situations, we try to work with clients to come up with a nuanced way of approaching that statement that, at least in some way takes responsibility for, yeah, I was aware my cousin was selling drugs, or I knew that that was a corner where that happened and I shouldn't have put myself in that situation. And I've learned from that, and now I don't hang out there anymore. I don't hang out with those people anymore, or whatever it is. There's usually some way to work with, what the court documents say happened and what the client says happened, and figure out a way to resolve inconsistencies and for the client to take some kind of responsibility for what happened. I'd say that's the most important for any kind of violent offense. If there was a victim involved, it's really important that that be the focus, that the person's taking any responsibility or remorse for any harm caused to a victim before they're talking about how they've been harmed by the record itself. So I think all of those pointers are still important, even with this board, although as we'll talk about later, hopefully that will start to change a little bit in the future. And our best practice here is to get we'll talk in a minute about all the court documents you need to get anyway for the pardon process. And I would recommend at the outset getting those documents before you even start to really get into it with clients on drafting these essays, because it's just really helpful to know what the baseline is, what the police report says, what the court documents say happened. So as the client's telling you their story, you're kind of aware of that, and you can start thinking through with your client how to explain any inconsistencies between the two. But I think that's kind of the hardest part of all of this, and the area in which having an advocate help somebody can be the most impactful. And then this is a new component of the application. There used to be 3 different required essays that were about why you deserved a pardon and how you were rehabilitated and how you contribute to your community. And thankfully, they've consolidated that down to just one optional personal statement. Even though it says optional, we highly recommend that people do this personal statement because it's really the only opportunity an applicant has to tell the board about themselves, to tell their story, especially things about why they need a pardon, how they've changed their lives, why they're a good candidate, etc. So it's nice that it's a little bit less structured than it used to be, I think, because it really gives individuals a chance to kind of focus on what's important to them and the kind of story that they want to tell. But this is another area where advocates can be really helpful because sometimes you know, writing can be challenging, or trying to think about what to say can be stressful. And through asking a lot of good questions, you know, you can help pull out from clients, you know, what are the ways that you contribute in your community? What are, you know, the ways you've given back to your family or to your, you know, told your children about how, you know, what happened with you and how they can stay out of trouble. Things like that are all things the board likes to hear about. I would also think about how you can help your client craft a narrative. The Board of Pardons really likes good narrative. So whether it's, you know, I was struggling with a drug addiction and then I went to, you know, I got treatment and I've been clean for 10 years and I'm a leader in NA now and I help other people get clean, or if it's a story about how you were a young person hanging out with the wrong crowd, but after you got in trouble you realized that that's not, you know, the life you wanted and you had a family and now you're a totally different person. Whatever the person's story is, that kind of narrative arc where it's like, this is what was happening then, this is what changed, and this is who I am now, is really powerful, because at the end of the day, what the board is most concerned about is giving somebody a pardon and then them getting into some kind of, especially high profile, but some kind of additional legal trouble. So the more you can kind of reassure the board through helping your client craft this narrative that that's just very unlikely to ever happen, the more successful your client's likely to be in the process.
Jamie, if I could just interrupt here, for all the attorneys on the webinar who would like to request CLE credit, 1 substantive credit for the participation on the webinar today, there should be a pop-up box on your screen now. Please respond to the question, and then the pop-up box will go away. And you'll have 2 minutes to respond to this. Thank you. And you're welcome to go ahead, Jamie.
So the next thing, in addition to these essays that you'll help your client write, is that there's also an option to include supplemental information, and that can include things like certificates, awards, diplomas, letters of recommendation, things of that nature. And some of those are items your client may already have around or might have easily accessible to them, or they might not be. And as we'll talk about a little bit later, I wouldn't stress too much about acquiring these supplemental documents, but if there are things that clients have or can easily get, I certainly don't think it hurts to include them. It could definitely help. But again, I wouldn't stress too much if they don't have these things, or if it would be too hard for them to get a letter of recommendation, or if they're not comfortable explaining to somebody in their life about the fact that they're applying for a pardon. But it certainly can help if you do have this. Now, the part that's still the trickiest about all of this, and where having a legal advocate can be really helpful, is that people still need to acquire court documents from their case. And I've listed the list of court documents here so that you can see it. It's also on the application itself and online. But these particular pieces of paper that are in a criminal court file can be difficult to identify. And it's hard to always know if you have all of the right ones. Sometimes the courts have lost files because they're too old. If you can't actually get the file, you need a certified letter from the court saying that they don't have the file, or that what they've given you is the certified file. So all of that can be difficult to navigate. And I know in different counties, their rules on giving out this information are different. Some require that you pay for the documents. Some will mail them to you. Some you have to go to the courthouse in person. So in our office, what we do with our court here in Philadelphia is we have a high school student intern who is our court runner, and we have a scanner, and he goes over to the court and pulls files and is able to scan them so that we don't have to pay to access them. And then we just scan the whole file and then come back to the office and figure out which pieces of paper in the file we actually need to include in the application. So how you do it, how you approach that might be different, but I do think this is an area where having a legal advocate help instead of just sending the client to try to navigate this on their own will produce a better outcome, because even for us, like, even though I do this all the time, every time I look in a file, I still struggle to make sure, oh, is this the criminal information or the complaint? You know, does this count as a sentencing order? It says the sentence on it, but it's not labeled sentencing order. Things like that, you know, can be even tricky for us to figure out. So I definitely think that's an area where you're going to want to try to help people navigate. Sorry, I'm trying to advance, but my screen seems to be frozen. There we go. Okay. So some other changes to the process that have happened is that the board is trying to help a lot more people access the pardon process than they have in the recent past. So we've long represented our clients and gone to the public hearings in Harrisburg, and traditionally they've had 15, maybe 20 people per session, and now they're fitting in more like 30 to 40 people per session and trying to hold sessions more frequently. But it's really kind of changed. I don't know if anybody on the line has ever been to a Board of Pardons hearing, but it's really kind of changed the tone and tenor of the sessions. It used to be that when clients would get there, they would have 15 minutes, they would give kind of an opening remark about why they needed the pardon, and then the board would kind of barrage them with questions, and then people who were there to support them would talk, and as the attorney, you could talk if you had something you wanted to add, although they never liked hearing from lawyers very much. But now with so many people in each hearing, as you can imagine, there's not really time to do that for 30 to 40 people and still get out within the morning or the afternoon session. So now what tends to happen, especially for older, less serious offenses, is that they ask the individual if they want to jump straight to questioning instead of making opening remarks. And everybody pretty much says yes to that. And then the board will ask anywhere from 0 questions, depending on how old and minor the case is, to, you know, asking a few questions. They tend to ask questions, if anything in the offense related to drugs or alcohol, they'll probably ask about drug or alcohol history. If there's a DUI involved, they'll ask about, you know, not only drug or alcohol history since then, but whether you currently drive and any issues around driving that you've had. They'll often ask questions about like mental health and therapy and treatment, things of that nature. And they'll ask questions about the offense itself, if there were inconsistencies in the application versus the police report, or if they want to know more detail about an offense, especially for a more serious or more violent related offense. They might go into questions about that, but their questioning is definitely less intensive than it used to be given the volume, and it's kind of reserved for the more serious offenses. So there were plenty of people at the last hearing I went to who got up there and had no questions or had one question, and Lieutenant Governor Fetterman would end people's questioning by just asking them, like, how would a pardon improve your life? Or are you living your best life right now? Or whatever it was, to give people an opportunity to just say something positive about themselves, or he would identify something positive from their application. But the tenor is a lot more friendly, basically, than it used to be, and a lot more less intensive, and some people won't even have questions at all. The other big change for the better is that the vast majority of people at the hearing stage are being recommended. The past few times we've been there, there have only been like 1 or 2 out of the 40 who haven't been recommended, and for pretty clear reasons. And I'll just say that the board still seems particularly wary of pardoning any offense that has anything to do with children or anything to do with sexual offenses. Those still seem to be kind of the hardest to overcome. And a couple of other people I've seen over the past year or 2 who haven't gotten recommended are people with cases that involve drugs or alcohol who still utilize drugs or alcohol, especially in the context of driving. Those seem to be the cases the board is still a little bit wary about as well. But the vast majority of people who are making it to the hearing stage are getting recommended, which is really great. So now we're going to talk a little bit about the new Expedited Pardon Program. You may have seen it's been in the news a lot. There's been press conferences and articles about it. And it seems like it's still very much a work in progress. There's new information going up on the website link that's here pretty much every day. So it's always good to check back again to that website. But the basic gist is that any marijuana conviction, whether it's a felony or a misdemeanor, can be eligible for this expedited process unless an individual has another violent offense on their record. So even if the offense they're trying to get through the expedited process doesn't have anything violent on it, if they have a violent offense somewhere else on their record, or if they have a marijuana DUI on their record, unless it's a lawful medical marijuana card holder. So basically, for people who just have a marijuana conviction, whether it's misdemeanor or felony, this process is really terrific. Part of the challenge, though, is that when you're just looking at somebody's record, you're not necessarily going to know if it was a marijuana conviction or if it was for some other drug, because sometimes it's labeled marijuana as the offense, but for possession especially, but often it'll just say possession with intent to deliver or simple possession. And so you'd really have to ask the client and get the court documents to figure out that this is a marijuana case and not a different kind of drug. But the really amazing thing here, again, is that even felony cases can be considered. And it's been a little vague on the website. The information is a little confusing about the felony piece. So if somebody was dealing, selling, or distributing marijuana, our basic understanding at this point is that they're not too concerned with people who are selling or dealing small amounts of marijuana. They'd be a little bit more hesitant to do this expedited process for somebody who is part of a large distribution network. So, you know, if you can kind of ascertain through your clients or through the court documents what the volume was, that might be helpful. But the application for these two are the same. There's just now a box on the regular application that says expedited. And if they decide that somebody is not appropriate for expedited, they'll put them into the regular process. So there's not really a harm if you think they're eligible for expedited to click that box. And the worst case scenarios, they'll be put into the regular stream. The other thing that's really great about this new process is that the board has said they care less about how recent the conviction is and much more about how the pardon will help somebody's life. So, you know, if somebody has a marijuana conviction, you know, it would be eligible for a clean slate after 10 years, but 10 years is a long time to wait to clear your record for a marijuana conviction. So under this new process, for example, would just let people access relief a lot sooner. You know, it remains to be seen what they mean by that they don't care as much about how recent it is. I don't know what would happen if somebody was convicted yesterday and applied tomorrow. I would imagine having some amount of time pass is probably still helpful, but it definitely seems like that's less of a focus for this process, which is great. The other obviously huge benefit is the expedited part. The board estimates that this new process will take about 6 months to 1 year, as it will skip over the parole interview stage. So as we've been in some conversations with Secretary Flood, you know, it's become quite clear that the biggest piece of why the process takes so long is the parole interview stage. There are staffing issues with having parole agents available to do these, and it's just a time-consuming process for them to go out to people's houses and do the interviews and then be able to write their report and get that to the board. So since that really is the bulk of what takes so long, removing that stage is what's really going to speed this process up, as well as some other areas where they're going to try to move these cases faster. So we will all see whether it's 6 months, 1 year, or longer. But in any event, if you have clients in this boat, you know, now is a great time to get their applications in as quickly as possible. And if you do have cases that you're filing under this, we'd love for you to reach out and let us know, because we'd definitely be interested in hearing about what the experience is like and about how fast things are moving. So do keep in touch with us if you're seeing clients go through this process. So that's a lot of reforms that we've just talked about. It's really amazing to kind of look at the cumulative amount of changes that have happened and to look at what's required now and just realize how much easier this process has become. But that doesn't mean there aren't still more ways to make reforms. And, advocates have long been pushing to make this process more accessible and more equitable. And we're really fortunate now, Lieutenant Governor Fetterman and Secretary Flood are extremely committed to this goal. So if you have other ideas or suggestions for reform, I'm sure they would love to hear them. And they have some initiatives coming down the pike. None of these are super official yet, but just kind of things that we've heard in conversation. One that's more close to official is that they are working on an online application, which will just make it so much easier to be able to apply. And that's set right now to launch in the fall of 2020, so stay tuned for information about that. They're also looking at expanding the expedited review beyond just the marijuana convictions, which is something that we've really focused on in our advocacy, because we think that for a lot of kind of more low-level or older offenses, having this really in-depth parole agent interview stage is just really not necessary. That level of scrutiny and review for somebody who has a retail theft from 10 years, 20 years ago, or, a forgery case from 20 years ago, or whatever the categories are that they end up choosing. We just think expanding that expedited process and skipping that invasive and lengthy parole agent interview part is an area that will be really important going forward that we're hoping to see expanded. Another thing that is in contemplation right now is the idea of creating an innocence track. And that's to kind of get at what I was saying earlier about people who say, I pled guilty because I was being incarcerated and I wanted to get home to my children, but I really didn't do it. So I can't take responsibility for it. Having a track where people can put that forward, and not try to relitigate their entire case necessarily, but at least put forward the information they have to support that position, and to write about, why they should still get a pardon anyway. So that's something that might be coming down the pike. And then again, just obviously the biggest need, especially as more and more people are applying and taking advantage of this process, is that it's not going to help shorten the wait times any. So the Board of Pardons is seeking to get more staff and more resources so that they can deal with the influx of cases coming in. And again, looking at this role of the parole agent interview, trying to get more resources for the parole agents and minimizing that role in the process. I'll just note that after the board took away all the fees associated with applying for the pardon, within I think a couple of weeks, applications doubled. So of course, it's so wonderful that all these changes are opening up this process to more people, and especially more low-income people. But again, really what's needed then is just more resources for the board to be able to do their work more quickly so that people aren't waiting even longer to be able to get a pardon. And I just like to include this because, I feel like every time I talk about how long and burdensome and complicated the pardon process is, it can sound so discouraging. But when people get pardons, it's really just like the most joyous experience. So I wanted to include a couple of photos of times when I've been at the Board of Pardons with a variety of clients and staff, and just been able to see people get their pardons and be surrounded by their families and just have this moment of joy and hope, and then keeping in touch, often with pardon clients, you're working with them for many years, so you really develop close relationships in a way that you don't always get to in other types of work. And so over time, you hear back from clients about what they've been able to do since getting their pardon, and it really just can be one of the most life-changing things you can do for a client. So as hard and difficult as it is, I always try to tell clients and tell other people that it's work so worth doing, and if you think somebody is a good applicant, it's so worth encouraging them, especially now, to actually do it, because at the end of the long road, there is just a lot of hope and a lot of joy in the process. So I wanted to make sure to communicate that after talking about how complicated it is. So now we're just going to talk a little bit about what are the takeaways for your practice, and then we'll open it up for questions, which I hope there are lots of. So takeaways, I think I've said this like 8 times now, but I'll say it again. It's easier now than ever before to apply for and get a pardon. So this is really the time to do this work. So if you're a program that's done just advice or only a little bit of this work in the past, or if you haven't done this work at all, or if you've done some of it, but you're interested in doing more, there's not a better time than right now to do that, because of all of the reasons we've said, and because the Board of Pardons is subject to political changes, we don't know how long we'll have this moment for. So while we have this moment, we want to try to help as many people apply as possible. And to that end, I would just suggest not letting the perfect be the enemy of the good here. Even with colleagues here at CLS, we've talked about, the essay does not need to be perfect. Assure clients it doesn't need to have every last detail in it. If they can't get that last letter of recommendation from somebody, that's okay. Get as much good information in there as you can, as quickly as you can, and help your clients send in their applications and get their place in line as soon as possible. To help folks be able to do this more easily, as Kelly mentioned, after today's webinar, we'll be sharing some tools with you. One is a Word version we've created from the PDF that just makes it easier to type answers into the application than even doing it as a fillable PDF. Just in terms of the formatting, it's just more straightforward to use a Word version. So we'll share what we've created that's gotten approved by the board as a suitable document with you to try to ease the process of helping to fill those out. And we'll also share, we have a pardon checklist. That's just kind of the reminders that talks you through everything you need to do. And like I said, that changed even just this morning. So we're going to revise that and get you a checklist as well, just to kind of help you work through the process. And I thought it was just worth saying, I've said this kind of as we've been going throughout, but even with this simplified process, legal help still matters a lot. And if you can do legal help beyond advice, it's really, really important to actually help walk people through this process if you can. And some of the reasons for that is that obtaining and discerning which the correct court documents are is extremely complicated. Advocates are really best suited to help clients frame their explanations for what happened in the case in light of all of those court documents and in light of what you know about the Board of Pardons. Advocates can also help clients best frame their personal narrative, although I will note that it should definitely be in the client's voice. It shouldn't sound like a lawyer wrote it. The Board of Pardons kind of detests legalese and has never really liked to hear from attorneys because the whole point is to hear the client's story of redemption. And so it absolutely should be in your client's voice, but you can definitely help them think through all the information they want to include and how to frame it and actually help them commit it to words. And then even just filling out the application completely and accurately is still difficult, even for advocates. I supervise several people who work on pardons and regularly review pardons, and there are just so many tiny details to get right. For example, every single box needs to be filled out. So if it doesn't apply, you have to write NA in it. Somebody might not know that. And all the information about, what's the OTN number of this case, or what was the sentence or disposition on that charge. Those types of details are just difficult for people to be able to nail down. And so having a lawyer really sit with them and walk through that and fill that out is just absolutely immensely helpful for people. So please keep that in mind as you're thinking about how you might do more of this work. And I know resources are always an issue, so I just wanted to take a minute to say first, a lot of our programs have funding available through PLAN to actually help people apply for pardons. So if you're not sure if your program has funding or if you think you do, it might be something good to talk to your manager or to your program about, because there may be specific funding dedicated where you can get paid to help people submit their pardon applications. And then I also wanted to just mention something we've found really successful with expanding our resources to do this work is to work with volunteers. In particular, we've worked successfully with law students. This is a great opportunity for law students to get a really in-depth experience working directly with a client, get the experience of helping somebody fill out and submit an application. We've long had a project with Penn Law School, and this year we've launched one with Temple Law School as well, where we train law students and then we assign them one-on-one to work with a client on completing their application under our supervision. So we still review everything before it goes out the door and are available to answer questions, but we're able to really rely on the law students to try to move it forward with the client and develop the relationship and get all of the kind of substantive work done. So I would encourage you to think about that if you're looking for ways to kind of amplify your ability to do this work. And with that, I will open it up for whatever questions people have.
So if you have a question, please, again, click on the chat button at the bottom of your screen and type your question in. I'm also going to launch the second of the CLE credit polls right now. If you're an attorney requesting CLE credit for your participation in the webinar today, please respond to the question that should have just popped up on your screen right now. You'll have 2 minutes to respond to that. And Jamie, I have a number of questions and comments already if you want me to go ahead and start reading them.
Yeah, please do.
Okay. First we have, in order to do a pardon for a client, do we have to include a state police background check with the pardon petition?
No, that is one of the things that was eliminated. So there is no, the only things you need to submit are the court documents that I referenced earlier.
Okay, the next is, Jamie, please tell everyone that updates can be submitted at any time by letter mailed to the BOP. Just put application number. Another reason not to let excellent be the enemy of the good. Toby Oxholm.
So I think this comment is getting at the fact that once you submit the application, it used to be that if you had made an error, the board would send it back to you and make you fix it and then resubmit it. And that could be another way in which a lot of time would pass, and it was very frustrating because they would do it on very nitpicky grounds. But fortunately, this board is very willing to work with people and willing to try to just make the changes themselves. So one thing I would say is we didn't always used to put ourselves down as the contact for our clients when we filled out applications, but we've started doing that. If you put yourself as the representative on the actual application, the board will just reach out to you if there are any issues, and they'll just say, hey, we noticed these errors, can we fix them? And you just type back yes, and they'll just fix them and get it filed. So I would recommend that if you're representing somebody. If you're just giving somebody advice, then the biggest advice you can give them is just to make sure their information stays updated with the Board of Pardons so that when they reach out to the applicant about any issues or errors or additional information needed, they have a good contact address for them. And because this process can take a while, it's especially just important to remind clients if their address changes or if their phone changes to send that update into the board as well.
Okay, next question is, can a pardon be filed after a person's case has been sealed via clean slate?
Yes, and actually on the new application, there's a very helpful explainer for people about sealing versus pardons, and it explicitly says, and we've already gotten some pardons for people who've already had their records sealed, so we have seen it happen firsthand. There is no issue with applying for a pardon for somebody who's had their case sealed already. And as I referenced earlier, because of the FBI background check issue, there may be cases where somebody with a sealed record really needs a pardon, and so that's absolutely fine and not an issue at all.
We have a question. Why does Josh Shapiro always vote against?
I wish I could answer that. I will say that traditionally, I've been watching the board for my 8 years at CLS now, change over time, and whoever's in the Attorney General role always seems to be the biggest naysayer. I think it's something about the nature of that sort of law enforcement role, so I don't think it's unique to him. But I think even over time, he's started to become a little bit more forgiving. So hopefully the kind of tide turning here will sweep him up as well, and he'll get a little bit more forgiving. For the pardon process, it's not as important because, again, you only need 3 out of 5 votes. So if he votes no, it doesn't have that much effect. But it's really in the commutation process that's been a bigger issue because you need all 5 votes. And that is improving as well. More people are getting commutations now, and that's been another, that's not the topic of today's presentation, and that's not work we specifically do at CLS, but it's important work that's also expanding under this board. So I think we'll have to see kind of how much Mr. Shapiro gets pulled along with the tide of all of these changes.
Okay, next is a longer one. Since sealed cases can no longer be used by occupational licensees agencies under clean slate, will you provide some examples of how that provision will work? For example, does it apply to someone who wants to be a registered nurse Does it apply to someone who wants to get a CNA certification? What about a teacher? We understand that the specific prohibitions pertaining to certain professions are probably the type of cases that cannot be sealed. We would like to be able to adequately address these issues during presentations. Any insight you can provide would be appreciated.
So there's a lot packed into that one, so I'll try to address it all as best I can in light of the fact that we didn't talk a lot about clean slate today because this presentation was about pardons, but basically under clean slate, as I said earlier, FBI records will still reveal those results. However, they still cannot be considered in most circumstances. Most occupational licensing agencies will not have access to sealed records at all, and under clean slate, they're not allowed to view them. So anything that goes through the State Department Bureau of Occupational Licensing, which is the vast majority of licenses, sealed cases will not affect that. So for example, if you're trying to get your nursing license or your cosmetology license, those types of licenses will not be affected by sealed cases. Teachers, though, for example, teaching jobs are covered by the Child Protective Services law, and those jobs are ones where FBI checks are requested. So for somebody applying for a teaching job, if their record was sealed, it would still show up on an FBI check, but it still wouldn't be able to be considered for the job, which is a challenging situation. And we're here to advocate for people if they find themselves in that situation. But in that's exactly the kind of case I mentioned earlier, where even though the case has been sealed, if somebody has a career working with children, it's really going to be to their benefit to still apply for the pardon. Whether or not their case is one that would bar them, I mean, if they're working with children, they're probably not barred under the Child Protective Services law. But regardless of whether they're barred or not, it's to somebody's advantage to have a clear record if they can. So in those cases, I would recommend that somebody still apply for a pardon, even though their record has been sealed. So it really varies field to field, job to job. The more regulated and protected the population somebody is working with, the more likely even a sealed record is to affect them, and the more helpful a pardon probably is. Of course, if they have an offense directly related to children, it's a little bit less likely they'll get the pardon, and that's a little bit more related to the job, so it gets a little bit trickier. But for most people, yeah, I would recommend the pardon process as a good outcome for them if they're in any of those kind of protected jobs.
Okay, the next is the first page of the application at the bottom asks for contact information for a, quote, representative, unquote. This should be understood as the applicant's fallback. Many of our clients will not have the same phone number in 2 years or live at the same address. We, PLSE, recommend that applicants put the name and address of a parent, best friend, or organization that can get in touch with the applicant.
So again, I would say for us, where we're representing people applying for pardons, I would put our information. It's just going to be easier for people all around if you're representing them to have you as the representative. If you're not actually representing people, if you're just giving them advice, then sure, that could be helpful advice. But if you are representing people, my recommendation would be to put your information as the representative. Not only will that allow you to handle any errors or issues that come up, it'll also allow you to check in on the status of the application as time passes. It'll allow you to just have access to information about your client's case in a way that you wouldn't if you weren't listed as the representative. And it doesn't commit you to go with them to a hearing in Harrisburg necessarily. That's still something you could decide with the client later. But it just allows you to be the main liaison so that when somebody's address changes or phone number changes, it's not going to be as big an issue for them. So again, if you're representing somebody, my recommendation would be to put your information as the representative. And if you're not, then, whatever the most stable contact information that person has, I would put.
Okay, next one. So pardon, then expunge for DUI, however, still on DMV. How can we get that loophole changed?
So I think this issue is that PennDOT does not expunge records. So even if you get a driving record expunged or a DUI case pardoned and expunged, PennDOT is not required under the expungement laws. They're not a law enforcement agency who's subject to an expungement order, and so they refuse to clear their records. So there would have to be some kind of legislative change to require them to do that in order to remove that from somebody's driving record. That would unfortunately be the only way to address that problem as of right now for the driving record in particular.
Okay, and does any of this cover whether someone was indicated for abuse by CYS?
That's a great question. That could be a whole separate webinar. This does not cover that at all, although we have recently had a few cases where we've wondered if getting somebody a pardon because of the sort of innocence that it confers and the restoration of rights that it conveys, if you were, so this gets into a very complicated area of the child abuse expungement world, but basically if you're convicted of an offense like endangering the welfare of a child, you can just be founded and kept on the child abuse registry without a hearing because you were already convicted of an offense arising of the same incident in criminal court. So we have started to explore whether getting a pardon on the endangering the welfare of a child case would then open you up to be able to challenge and expunge the founded child abuse report. I don't think we have a quite clear answer on that yet, but the more simple answer is if you get a pardon on your case, but you're also on the child abuse registry, there's a separate civil process for getting off the child abuse registry that you'd still have to go through. And again, that can be complicated if you were convicted on the same offense. Because it might already have been a founded report. But if anybody wants to know more about the child abuse registry process or the interplay of these things, I know we're running short on time today, so feel free to reach out, and I'll also put up our contact slide at this point, but feel free to reach out directly. Our office handles a lot of child abuse expungement cases also, and so we'd be happy to talk with you more about sort of the interplay of those issues.
Okay, great. And I don't see that we've had any other new questions come in. So I think we're good.
Okay,
Jamie,
thank you.
Do you have anything else?
No, I was just going to say my email address is up here. I know many of the people who are on the line are people I talk to regularly, but if you're not one of the people I talk to regularly, feel free to reach out anytime. I try to be really responsive to questions and help however we can. So don't be shy about reaching out if you have any follow-up questions after today, and we'll make sure to circulate our resources as well.
Great. Thanks. Thank you so much, Jamie, for presenting all of this information and for everyone for joining us. I hope you have a great rest of the day.
Bye.
Bye-bye.